Welcome back. Be seated, please. Let's call the next case CENTERSTATE Bank versus KRAUSE.
Good morning.
Morning.
May it please the Court. My name is Christy Hatcher-Bolin, and together with Mark Miller and Monterey Campbell, I represent the appellate CENTERSTATE Bank. If I could, I would like to reserve 3 minutes for rebuttal. This is a mortgage foreclosure action. CENTERSTATE sought to foreclose against an entity known as KRAUSE Groves Enterprises on 2 sets of notes and mortgages encumbering 2 different parcels of land. The first note and mortgage in this case is not at issue, and there was a stipulated final judgment of foreclosure entered on September 8, 2010. What's at issue in this appeal?
We understand that this is the second, I guess everybody's called the development loan, the one that covers everything but the original 5 lots.
That is correct.
I think we understand that's the one at issue. Help me understand. Let's talk a little bit about the standing of the KRAUSEs. Clearly they had filed a lis pendens, and as a result, you had to join them in the lawsuit, I guess, to wipe out or in an attempt to wipe out their lis pendens. But is standing for one issue equate to standing for every issue? I mean, essentially their argument is that you, CENTERSTATE, can't foreclose your mortgage, irrespective of what interest we may have in the land. You can't foreclose your mortgage because your mortgage was void. It wasn't properly executed by, was it KKG or
KGE, KRAUSE Groves Enterprises and Ross.
So let's talk about what gives them standing, or in your case, what doesn't give. Your argument is that they don't have standing to raise the alleged defects in the execution of the mortgage.
That's correct. We do not contend that they don't have standing to contest priority. They filed a lis pendens. We had to join them as defendants in order to foreclose their interest. What we're contending, though, is that they don't have standing because they were not parties to the note and mortgage, and they didn't have an interest, any type of record or possessory or fee interest in the property at the time that these mortgages were executed.
And it's my understanding that I know they have a separate lawsuit pending. That separate lawsuit doesn't try to get them into the limited liability company. It tries to impose a constructive trust or essentially unwind the deal and give them their land back. Is that correct?
Yes, it's to unwind the deal that they had with KGE. Actually, I guess the warranty deeds. They want a constructive trust and an equitable lien over
They're
that
not trying
property.
to force their way in. They're not trying to redo the deal and say, hey, KGE, give us the KRAUSEs half of the limited liability company or whatever their portion was. They're not trying to say that. They're trying to say, undo the deal. We were defrauded into the transaction and give us back our land. Is that?
Well, first of all, CENTERSTATE was not a party to that other case. They have injected, the KRAUSEs have injected this into our lawsuit because they're saying that, look, by virtue of this equitable or this action for equitable lien and constructive trust, and by virtue of our lis pendens, that we have standing to challenge the validity of the notes and mortgages to which they were not parties. If you look at the case of Hayes v. Guardianship of Thomas, the court specifies, that's a Florida Supreme Court from 2006 case, they say you have to look at that standing to bring or participate in a particular legal action often depends on the nature of the interest asserted. Here, the KRAUSEs have not simply argued priority, which we agree. They can argue priority. They have every right to argue priority. Rather, they've tried to challenge the validity of notes and mortgages to which they were not parties. Here, the interest that they assert actually belongs to KGE and to Wilson.
Well, if they have a right to argue priority, you can only have a prior interest. In other words, CENTERSTATE could only have a prior interest if it had an interest at all. Obviously, they have to have an interest before you can even argue about its priority. Would you agree with me?
I agree, and the interest is the recorded mortgage that was recorded prior to.
In this case, their argument is that mortgage is void because of execution issues. I mean, if CENTERSTATE had recorded, for whatever reason, forget the fact that the mortgage was improperly executed. Let's just say they accidentally recorded a blank mortgage, had the right legal description, the right names of the parties, but it had never been executed by anyone. They had that in their file somewhere. Could the Krauses come in and say, you can't be prior to us because your mortgage was never even signed? In other words, your mortgage is invalid.
Well, that same argument was actually raised in the Hutchinson case. The Hutchinson case, and that was basically a mortgage foreclosure case where there was some sort of mess up. I don't know who exactly did it, but when they went to actually execute on the sale, they got the wrong description. It was the wrong address. And so they go to actually evict the guy who did buy from the foreclosure defendant, but it's a separate parcel, it's not under foreclosure. And they said, well, your deed's defective. And the court said, well, your deed's defective, but you had a possessory interest, and you did have a record interest, even if the deed itself was not valid. So he did have standing in that case because he was challenging basically being evicted based upon his interest in the property. He had a deed, he had a possessory interest. So in your example, although we contend that's not the case, if you had a mortgage, and we do have a mortgage, and it was properly executed, what they're challenging, and actually it's not really the execution, they are challenging whether or not Mr. Ross had authority to execute that mortgage. And they expand and say that it was an ultra vires act. And that was the basis for the judge's decision, which we contend you don't even go there because they don't have standing to challenge the note in the mortgage. They weren't parties to the transaction. They didn't have a record of possessory interest in the property, which is in some ways is kind of astounding because Mr. Krause testified that he knew they had agreed that that KGE, the LLC, was going to obtain financing on this property, but they never discussed taking back a mortgage on the property or recording this oral joint venture agreement. But this is not an ultra vires act. If you look under Chapter 608, this is exactly the type of action that an LLC is privileged to take unless either the operating agreement or their articles of organization prohibit them from doing that.
Before you go or continue on the ultra vires, let me get back to the standing. If there was a fraudulent situation between the bank and KSE, could the Krauses attempt to go behind that?
I think that somewhat goes to priority. If they knew that there was some sort of fraudulent activity, they knew about the Krauses' interest, they knew the Krauses were involved, but that's something they didn't prove, then yes, they might have standing to challenge it. But again, here, they're not actually asserting their priority interest. They're asserting the interest of KGE almost as a volunteer on behalf of KGE or Wilson, saying Ross didn't have authority to make that.
Well, instead of Mr. Ross signing, what if the bank official had signed the mortgage purportedly on behalf of KSE? So totally fraudulent mortgage document. So
someone who wasn't a member of KGE?
Yeah.
Then I would say in that case it's voidable at the option of the corporation.
No, but could the Krauses bring the action when they have standing? Again, challenging a agreement between KSE, the validity of agreement between KSE and the bank. I understand your argument that we don't want people coming in as volunteers, if you would, saying this contract between these two entities is invalid when they're not a party to the contract. But how about in a situation where you just have blatant fraud?
Where you have blatant fraud. The cases don't address it in terms of standing, but certainly they have said that if it's an ultra vires act, it's something that they didn't have authority to do. There have been cases, for example, where someone who wasn't even a member of the corporation or who was not a president, who hadn't been president for 2 years, challenged it. But still, you would have to have some sort of record or possessory interest in the property, and they didn't do that. They didn't do that here. They had every opportunity.
Well, then are you saying that Krause did have standing if they could show it's an ultra vires act, but they don't have standing if it's not an ultra vires act?
No, what I mean is that they still have to show some sort of interest. And here, their problem, their cause of action, is against the wrongdoer. It's not against CENTERSTATE, who didn't know about their interest, who didn't have any type of notice. constructive or otherwise. We contend they didn't even show that it was their burden to prove actual notice in the absence of constructive notice, and they didn't prove it.
Well, let's talk a little bit about the notice. It's undisputed that the statute, there's no operating agreement here.
Correct.
The statute says in the absence of an operating agreement or some other restriction, any of the managers could execute a mortgage. So, but for the two resolutions that the bank itself required, that required both Ross and Wilson to sign, we wouldn't be having, well, we might be having this conversation, but you would probably be resting much easier if that didn't exist. What about the fact that, if I understand it correctly, the bank has them sign this resolution that says, we're the two managing members and we will only act together. And then it seems like a week or so later, not very long thereafter, I can't remember if it's Ross or Wilson, I think it's Ross shows up at the bank, borrows the loan that's in question now and signs a resolution that says, I'm the only game in town, Wilson's not involved anymore. I mean, I understand that the record evidence is that the bank looked on SunBiz or looked on the state website and to see what was there. Should they have done? Does the statute require them to have done any more? Did that give them actual notice?
No, the statute does not. In the absence of fraud, which has not been shown, they have no independent duty to investigate. There are several cases, again, they're the ones dealing with ultra-virus actions that say unless there is fraud. For example, one of the examples is where American Business versus First Bank of Lantana. That actually, I don't know if they equated it to fraud, but they said if you're pledging corporate assets for a personal loan, we don't have that case here. This was a loan that was given to KGE. It was not given to Ross. They might have had a reason to investigate, then they might have been put on notice. As a matter of fact, the whole personal loan, or pledging corporate assets for a personal loan, was cited as basically the notable fact by the 4th DCA in American Business versus First Bank of Lantana. And then again, in subsequent cases, I'm going to butcher the name, Prezuzio versus Cameron, and Ocean Bank of Miami versus Univision, I think it's corporation. Again, the court said, look, if you're taking these corporate assets, you're pledging them for a personal loan, then yeah, you're on a duty. You need to see that they're doing this. But beyond that, in the absence of fraud or intentional misrepresentation or deception by the bank, there is no duty for them to go and investigate. And as between the wrongdoers and the bank, who gave value, the bank gave value, $700,000. I mean, in everything but name, they asserted a cause of action for rescission as a volunteer for KGE and for Wilson, in everything but name. And so...
Well, but it seems to me that we have to draw a distinction between an act that is outside the authority of the corporation and an act that is outside the authority of an officer or representative of the corporation. I don't think anybody disputes here that the corporation has the legal ability to borrow money.
Correct.
So, for example, if this had been a limited purpose corporation, the purpose of which was to run a casino, and they decided to go out and buy an orange grove and build houses, that might be an ultra-virus act because it was outside the authority of the corporation. I
agree.
This seems to be a situation of the question is more one of agency, and that is, did the representative of the corporation, in this case, I think it's Ross, have the authority to bind the corporation, and did the bank have some duty to inquire further? And was it somehow ratified? I mean, don't you think those are different concepts, and the focus here ought to be on the latter question of the authority of Ross to sign and the bank's duty or lack of duty to inquire?
And that's what we've argued. That's what we argued at the trial court. The most analogous cases are the corporate cases, where under 692.01, it basically says that anybody who has apparent authority under a corporation, and those are the most analogous cases, and those are the ones that the court cited in the American Business case. that you don't have a duty to go behind and try to investigate the corporation if they've got authority. And similarly here, where we have articles of organization that say it's for any and all lawful purpose, and where 608 expressly allows them to mortgage property to the LLC, the bank does not have a duty to investigate. Kind of a similar case happened, and again, it's that he might not have authority, but it's voidable at the option of the corporation, not a third party who has no interest. I mean, if a shareholder cannot even insert an individual cause of action for wrongdoing to the company, it's how does a third party come in who's not even involved?
What would happen? You know, let's assume that KGE, the janitor comes down to the bank and says, I want to borrow $700,000, and the bank has him sign the papers. Is the corporation bound to repay that money?
I think you're talking about someone who's not an officer or director, and probably a janitor would not even have apparent authority. Here we're talking about a member of an LLC, a small LLC. And I think under those circumstances, especially where they check it out on Sunbiz and he shows that he's the only officer or the only member at the time, and subsequently, like I said, it's voidable at the option of the corporation, and the corporation later, or in this case, I'm sorry, the LLC ratified it. In Spurrier versus United.
It seems odd that if there's a wrongdoer, that the wrongdoer can ratify his own wrongful act. And I'm not suggesting by the question that I've reached the conclusion that there was a wrongdoer here, but you know, I'm not sure that I am crazy about your ratification theory, because it's who they contend is the wrongdoer who is ratifying his own allegedly wrongful act.
And I understand that. Again, we're not here to defend Ross, but we did not have we were not involved, CenterState was not involved, and as far as the wrongdoing is concerned, that has to do with the Krause's separate action with Ross and Wilson and KGE over their oral joint venture agreement. That doesn't have anything to do with the actions as between the bank who gave value and took back a mortgage.
Let me ask you.
You got 3 minutes, by the way.
If the janitor had, instead of Mr. Ross in this case, if the janitor had signed the note and the mortgage, would the Krauses have standing?
Again, I don't think that really goes to standing, but they would still have to find an interest. Although I agree that I don't think the janitor would have authority, and I think that the bank under those circumstances would probably have to look into it further. If you may, I will reserve the rest of my time.
Thank you.
Thank you.
May it please the Court, my name is Greg McNeil. I'm here on behalf of James and Daphne Krause, the defendants in the case.
Mr. McNeil, you agree that the existence of a lis pendens doesn't create an interest in property?
That's correct, yes, Your Honor.
And so I guess I haven't done a very good job with my clock operation. Okay, so you're going to get an extra 10 seconds.
Thank you.
My little gift to you. So if it doesn't create an interest in property, it puts the world on notice that there's some litigation, that the Krauses are claiming that because of this unrelated transaction. I mean, why do they have any more standing to contest the bank's mortgage than I might?
Well, the reason that the standing exists for the Krauses, as the cases that we actually agree with CenterState on talk about, that all standing requires is that a litigant be able to demonstrate that the action will have some impact, direct or indirect, upon their interest in the matter.
Is standing, though, I mean, is it all or nothing? Or you know, they clearly had to, assuming that they wanted to end up with a clean title, they clearly had to join you in the lawsuit because of the lis pendens. But does that, it seems odd, if that doesn't create an interest, all it does is put the world on notice of the existence of a dispute concerning the property, that you can then create your own standing. I mean, I could go create standing if you're involved in litigation involving property and I'd like to stick my nose into it. I could go file a lis pendens. I mean, there's nothing, maybe you could bring a slander of title action, but, you know, other than that, if I just want to be a troublemaker, I can file a lis pendens on any piece of property I want to.
Yes, sir.
It doesn't seem that I would then have standing to raise any issue that any of the litigants could. I mean, it doesn't seem like it's an all or nothing, that there could be limited standing for limited purposes.
Your Honor, I guess the way I would respond to that is it's not the lis pendens that creates the standing. It is the claim for equitable lien and constructive trust which the Krauses have made against this property as a consequence of the joint venture that was entered into and then was ultimately breached by Mr. Ross when he surreptitiously went to CenterState Bank and mortgaged the rest of the property and put the money in his pocket. It is the claim of equitable lien and constructive trust that required...
None of that had been adjudicated. It
has not been adjudicated, Your Honor. Absolutely not.
So again, it seems to me that, I mean, I could file a lis pendens on this property and claim that I had an interest in it, that Mr. Ross was supposed to give me. I mean, it might be complete poppycock, and I'm not suggesting that the Krause's position is poppycock. I mean, I recognize that there's a substantial difference, but it seems to me that making a claim and having that claim adjudicated, they're not trying to get into the LLC. They're trying to unwind the deal. And I have trouble with this idea. I mean, it seems to me that they're a stranger to the transaction and that all of it could have been avoided by them simply actually getting some legal advice when they got in bed with this guy.
You're absolutely right about that, Your Honor, and that's a conversation that's been had. But as with regard to the legal issue of the standing, CenterState's position is, and keep in mind, the Krauses didn't interject themselves into the foreclosure action. They were named as defendants.
But they had to be named because of your lis pendens.
Well, if it's CenterState's position that we have no interest in the property, therefore no standing, then we wouldn't have to be named as defendants, and they could take the risk that they wouldn't get clean title if my clients prevailed in the companion lawsuit, which resulted in the impressment of an equitable lien.
Well, but at the very least, that ties up their ability to dispose of the property until you decide to resolve your lawsuit.
Yes, sir. That is true.
Which doesn't seem like the way to run the railroad.
Well, Your Honor, the problem of which CenterState complains is one created by their own doing. And in this particular case, it is true that my clients, if they had recorded an interest in the property based upon a joint venture agreement that would have been typically entered into with good legal counsel, then we likely wouldn't be here today. But we also wouldn't be here today if CenterState had simply abided by the corporate resolutions that they had in their file, which required both Mr. Ross and Mr. Wilson to sign on any note or mortgage which bound KGE.
Let me ask you this. If shortly after this questionable mortgage was entered into between KGE and the bank, MasterCard got a judgment against KGE. It hadn't been paid on their bill. And so now they can, try to execute on the property. Now they know they're behind the bank unless there's something wrong with the bank's mortgage. Could that judgment creditor try to go behind the transaction and say this is an invalid mortgage and therefore we want it set aside so that we have priority on being able to execute on this property?
If MasterCard had recorded a judgment in Osceola County against the KGE property and were named as a defendant in the CenterState litigation? Yeah. Yes, Your Honor, I think they could, because they clearly would have an interest in the property that has to be extinguished in the foreclosure, and as a consequence,
but a judgment lien gives them an interest in the property.
Yes,
and then you're only fighting about priority.
Yes, sir.
An LP doesn't give you anything.
No, sir, does not.
And so it seems to me to be, really a completely different animal.
Except that you're saying if KGE had 20 judgment creditors, each one of those could attack the validity of the mortgage.
If they were recorded in the public records of Osceola County and created a lien under the statutes, yes, Your Honor, because they would have standing based on those judgments, which would have to be extinguished by CenterState's foreclosure.
Well, although they have standing to the extent they have an interest in the property, they have standing to attack the validity of the agreement.
CenterState's burden is to prove that they have a mortgage. They don't have a mortgage. In order to extinguish my client's interest or anyone else's interest who's a defendant, they have to prove that they have a valid mortgage which is superior to any other junior or inferior interest in the property. They don't have a valid mortgage. That's not in dispute.
Well, let's talk about the validity of the mortgage. 608-4235 says, unless the articles or operating agreement limit the authority of a member, any member or manager may sign and deliver instruments affecting their interest in property. It's conclusive for anyone who gives value without knowledge. Knowledge means actual knowledge. So help me understand. I think we both agree that there is no operating agreement, and the articles of incorporation don't speak to this. So we got the two resolutions that the bank has them sign that says we both have to sign to conduct business. I mean, what is it about those that says that can't be changed?
I believe, Your Honor, under 608-4235 and both of those statutory sections that dealing with limited liability companies, since that's what we have here, they both say that the bank is entitled to rely upon the apparent authority of that member unless they have knowledge of any restriction upon that authority. When CenterState made the second loan, they had specific actual knowledge of a restriction upon Mr. Ross's authority to sign by himself and bind KGE.
Restriction was imposed by the bank, not by the LLC.
That is true, Your Honor, except it wasn't a resolution of the LLC and became part of their books and records. And the last part of the resolution does say that it will stay in force and effect until lawfully revoked, or I'm not sure what the exact language is right now. But yes, the bank did prepare those, and the bank did require that they be executed. So it's our position that under 608-4235, CenterState cannot rely upon the whole string of cases which they've cited regarding duty to investigate and so forth, and the ability to rely upon apparent authority, because they had specific actual knowledge of the restriction on Mr. Ross's authority.
Let me ask you, if Mr. Ross had gone and signed this mortgage and gone back and told Mr. Wilson about the deal and that he got a great interest rate, could Mr. Wilson say, great, let's do it? You should have told me beforehand. I would have gone down and signed with you. But if if the mortgage is already done, you got a good interest rate, let's get the money and let's go. Is it a valid mortgage?
Well, Your Honor, that introduces some questions about whether Mr. Wilson's verbal discussion with Mr. Ross might constitute a ratification because he was the other 50% managing member of KGE. So could they argue, if those facts existed, that was somehow a ratification of Mr. Ross's wrongful act? I suppose it's possible.
Well, and if it is subject to being ratified, does that make it voidable rather than void?
Not in this case, Your Honor, because the mortgage itself is ineffective to create a lien on KGE's property because it simply wasn't executed properly.
Well, if it could be ratified, but on its face it looks valid.
If you looked at it in public records and didn't know better.
You have an agent of the limited partnership signing.
Yes, sir.
And so on its face it looks good. Mr. Wilson has the ability to say, good move, Mr. Ross. We got a good loan, good mortgage. So it is subject to being ratified. May or may not have been in this case, but it is subject to being ratified. Now, a void act is not subject to being ratified, correct?
I do not know, Your Honor. I do not know. In the case law that I reviewed for this case, I don't recall that distinction being made in the context of ratification.
Because if it's voidable rather than void, who has to void it? I mean, it seems to me a third party can't come in and void it then. If it's voidable, it seems to me that either KGE has to declare it void or the bank has to declare it void, but a third party can't. And that's why it's significant whether it's void or voidable.
I believe the reason, Your Honor, is, first of all, there's obviously been no ratification of the mortgage by anyone. The trial court found that Mr. Ross could not ratify his own wrongful act 3.5 years after the fact. And after CenterState clearly at that point had notice and knowledge of my client's interest, the lis pendens was posted. The trial court conducted an evidentiary hearing, required us to post a bond. We stated a cause of action for constructive trust and equitable lien. And then 3 years later, he wants to come in and now try to ratify his improper act and have it relate back. And the trial
But the
court
court
said,
found that this was a void mortgage. And I think that there's I can only imagine that it's a void mortgage if the corporation was without authority to do this under any circumstances. And I think clearly the corporation had the authority to do it. Whether it was properly authorized by the people that did it, I think then enters into this question of whether it's voidable. In other words, as Judge Evander said, if he borrowed the money and Wilson said, well, okay, fine, we'll use it for corporate purposes. I don't know why that isn't a voidable thing, that maybe Wilson could come in and squawk about it, or maybe someone who had an identifiable, adjudicated interest in the property. Hold on just a second. You all right, Jay?
I'm sorry.
That's okay. Just take a minute.
Go ahead.
Somebody who had an identifiable, adjudicated, or undisputed interest in the property might be able to raise. But, your clients, they clearly were former owners and they felt like they'd been defrauded and filed the LP, but, the LP just doesn't give them an interest in property. I'm having a hard time understanding how they have any more interest in this property than I do.
well, Your Honor, I would give you a different analogy. If, for example, CenterState claims that they did not have notice or knowledge of the Krause's interest at the time they made the second loan. And while that was part of their motion for summary judgment, which was denied at the trial court level, because there was, in fact, some evidence in the record with regard to Mr. Krause's, I'm sorry, with regard to the loan officer's knowledge of the Krause's involvement. But putting that aside for a moment, if 5 years later, after the mortgage was put in place, let's say on a residential home, a contractor came along and did some work on the property to improve it, and then they recorded a lien, and now CenterState is foreclosing their interest, certainly the lienor, the person who rendered the labor, service, and materials to the property, would be able, as part of being a defendant in the litigation, to make CenterState prove that they have a valid mortgage which they're seeking to foreclose. Because until they prove they have a valid mortgage, that we don't get to the question of junior, inferior, and subordinate. But they have to plead and prove a valid first mortgage in order to establish priority over some subsequent lienor, or any other person who may claim an interest in the property under what other legal theory. And I don't want to lose sight of the fact that we're talking about an equitable lien and constructive...
But you're equating a lis pendens with a lien. And
I didn't mean to.
That's where your argument goes off the tracks.
Okay. I don't mean to do that, Your
They're
Honor.
just two different animals.
Yes, sir. What I want to do...
One creates an interest in... Well, one encumbers a piece of property. It doesn't create a property interest. And one of them really doesn't do anything other than give notice.
Yes, sir. The equitable lien, constructive trust, those causes of action are the causes of action which give the Krause's standing, not the notice of lis pendens. I agree with the court. The notice of lis pendens in and of itself, if there was no validity, if you said as a stranger you just simply recorded a lis pendens just because you felt like it, that would not create an interest in property. You'd still get named in the foreclosure action, but it wouldn't create an interest in property. I don't think you would have standing in that scenario if you just simply recorded a lis pendens. But of course, that's not our facts. And the Florida Supreme Court has said several times that equitable lien impresses a charge upon the property. So if they're going to foreclose my client's...
Not before it's adjudicated, though.
Well, that is true. That they have to be able
Because
to...
if that's the case, again, I can file an equitable action against you claiming an interest in your house. And, I don't think any of us would think that that creates an interest, that it would give me an interest until it might be finally adjudicated.
Right. Well, I guess the flip side would be if you determine that the Krauses didn't have standing within the context of the foreclosure action, and CenterState were allowed to foreclose their mortgage, and the the lawsuit with regard to the constructive trust and equitable lien proceeds as it would, then you would have a situation where the trial court could award relief in the form of an equitable lien against property, which has been previously foreclosed upon based upon an invalid mortgage. So I don't, it gets the cart ahead of the horse in that scenario. I agree with you.
Your clients have put themselves in this position.
Yes, sir. I don't disagree with that. If they'd have had legal counsel at the time and recorded an interest, Your Honor, we wouldn't be here today. That is true. But I don't know how it would work otherwise if they prevailed on their equitable lien claim and proved that what Mr. Ross did was fraud, and the trial court in equity, which it has the power to do, impressed a lien upon this property, subsequent to CENTERSTATE being allowed to foreclose their mortgage. And I don't know how procedurally that where we would find ourselves if they're allowed to foreclose a mortgage which was improperly executed from the very beginning.
Yeah, I mean, and we all understand, that looking at it globally, that there might be, some harshness to the result. That your clients could win could potentially win the other litigation and have an empty victory.
It would be eliminating a remedy which the trial court has found state's cause of action and allowed lis pendens to be filed on, all because of a determination that because that remedy hasn't yet been completed in trial court, the mortgage foreclosure was allowed to proceed, and the Krauses weren't able to point out the obvious defects in the mortgage that was being foreclosed. I see that I have 1:40 left, and if there are any further questions, I'll take them at this time. If not, I appreciate your time this morning.
Thank you.
Thank you.
Just a few things I wanted to bring up in the allotted time that I have left. And I think this was actually brought up by Judge Evander. If the Krauses could actually point to a defect on the face of the mortgage, then they might be able to challenge it. But they can't look behind the transaction, and that's what they're doing here. They're not parties to it, and they're trying to look behind the transaction to avoid it. And because they're not parties and didn't record their interest in the property, they simply cannot do that. CENTERSTATE gave value to KRAUSE Enterprises, $700,000 in credit, and KRAUSE Enterprises gave a mortgage for that. To allow non-parties to look behind transactions would wreak havoc on the banking system, on all sorts of commercial transactions, just because they find some fault with it.
What about the argument that they make that some of the money was advanced after the bank was notified by Wilson that the deal wasn't kosher, that he hadn't authorized it? And I don't remember what the amount was, but it's not relevant. I mean, could the trial court go back now and say, all right, well, you're okay for the first $500,000, but you dispersed the second $200,000 after you had noticed that this deal wasn't kosher?
Well, I'm not sure exactly if that was as to the first or the second mortgage. I know that in late April of 2007, and this actually comes directly from the second amended counterclaim, they say that Wilson became concerned, and that's when he went to the bank, and that's when the Krauses got involved, after all of this happened. But again, that's something that the parties to the transaction need to challenge, not these third parties who have no relationships. So it could have been Wilson, it could have been KGE. They didn't do that. So our contention here, again, that the Krauses bear the burden of proving some actual notice, because there certainly wasn't any constructive notice. They didn't take the opportunity to record their interest. They had no interest in KRAUSE Enterprises, and because they lack standing, the Krauses should not have even been able to challenge the notes and mortgages. You just simply can't have third parties going behind transactions to which they're not parties.
What happens, as Mr. McNeil says, so let's assume for the sake of discussion that we send the case back, the trial judge enters a judgment of foreclosure in favor of your clients, you buy the property at the sale. So now CENTERSTATE Bank is the owner. They continue their lawsuit with KGE, and the court unwinds that deal and says, okay, the Krauses were defrauded, and we're going to unwind the deal. Where does that leave everybody?
Unfortunately, I don't think they can. I think they're going to cause of action for rescission, which is essentially what they would be doing if they unwound the deal. You'd have to be capable of doing it. And after they've already conveyed away all their
Or let's say that
interest.
the court says that they were defrauded and, imposes well, I guess you can't impose an equitable lien if they don't own the property anymore.
That would be our contention, because and somebody who's not even a party to the lawsuit would be the property owner at that point.
Let me ask you this. When you file the mortgage foreclosure complaint, you say, we have a mortgage, it's in default, we're accelerating, foreclosing. These other defendants may have an interest in the property, but our interest is superior. All right, so the defendant says, denied. We deny you have a mortgage. I mean, do they have standing to say we deny that you have a mortgage?
I think they
Or
only
valid
have
mortgage?
I think they only have standing if they can show on the face of the mortgage that it's defective. And that's not the case here. They're reaching behind and looking into the transaction.
All right,
Thank you
ma'am,
for your
thank you
time.
so much. Appreciate your arguments on both sides.